All right, we're back with our second part of our Section 4 discussion on searches. So, by far the most common kind of search that police do is not searches with a warrant, but searches with consent. So, in other words, cops or law enforcement officers of some kind will just say, hey, do you mind if I search this thing, your bag, your car, your room, whatever? And as long as that person gives consent, then they don't need a warrant. The Supreme Court has kind of held that as long as they have the permission of the person who owns and controls the thing being searched, then it's not an unreasonable search and thus isn't protected by the Fourth Amendment. But the important part here is that it has to be a genuine request from the law enforcement officer. It can't come off as a demand. It can't come off as you have to let me. It has to be a genuine request for consent, and then that consent from the civilian has to be genuinely given. Okay? They can't feel bullied into it. They can't feel pressured into it. They can't feel like they have to say yes. It has to be genuine request and genuine consent. And even when they consent, they are perfectly within their rights to limit the scope of the search. In other words, they can say, yes, you can search this backpack, but you can't search my purse. Or you can search this pocket of the backpack, but you can't search this other pocket of the backpack. Things like that. And in addition, they have the right to withdraw consent at any time. But keep in mind, plain view and plain touch and plain smell and all those things still apply. So if a police officer is searching a bag, and he has the right to search the bag, the person is given consent. He opens up the bag and he sees what is obviously contraband, and then the person withdraws their consent. That's fine. The police officer can stop searching, but he's already seen it. It was in plain view. He was legally searching the bag at the time he saw the contraband in plain view. Stop. He can't search any further, but he can use that as probable cause to go forward with some other kind of search. Okay, even though they've withdrawn their consent, that only means that he can't search anymore under the consent search philosophy. But that officer can find some other way to either acquire the warrant or find some other reason to not require a warrant, which again, we're going to go over here. But the fact that they withdrew consent doesn't mean the officer has to pretend like they didn't see or feel or smell or hear whatever they saw or felt or heard or smelled. Okay? Now, what gets really complicated is when you kind of ask yourself, or it gets right down to it, and the question is, who has the right to consent to the search of certain things? So, for instance, if it's a minor, a minor's school backpack or a minor's bedroom, parents have the right to consent to the search of those things on behalf of the child. Okay? So the child's not there, police come, say, hey, do you mind if we search your son's room or your daughter's room or whatever? Parents are perfectly allowed to give consent, and that is valid legal consent, even though the person whose property it technically is, the child's, or the room is the child's, because they're parents, they have the ability to consent on behalf of the child. Same thing with an employer for employee work-related spaces and items. So for instance, I work at a university. I have a university-supplied laptop computer. Police can ask my employer for permission to search my work computer because it's technically their computer. They can also give the police permission to search my work office, right? My employer can't give permission to search my personal bag that's within my office. They can't give permission to search, say, if I have a personal laptop on me while I'm at work, they can't give permission to search that. But the employer can provide consent to search any employment-related space or material or thing that needs the police want to search. Same thing with a host-guest relationship. So if I'm spending the night at a friend's house, crashing on his couch, or staying with my friend for 2 or 3 nights, whatever, the host can give permission to search that area that I'm currently occupying on a temporary basis. A spouse can give permission to search a thing. So for instance, police want to search my computer. They come in, I'm not home, but my wife is. They say, ma'am, do you mind if we search this computer? She's allowed to say yes, because she's my spouse, and we can give permission to the police to search each other's belongings or things. And they're co-owners. So if I co-own a business with somebody else, 50-50 partners in a restaurant, police come and I'm there, my partner's not, police are allowed to say, hey, can I search this restaurant? I'm perfectly allowed to give consent on behalf of all the owners, as a co-owner myself. But importantly here, all of these people who can consent on someone else's behalf, their yes cannot override an in-person no. So if me and my wife are both home and the police come and ask permission to search my computer, if I say no and my wife says yes, her yes does not override my no. That doesn't count as consent. Even though my wife is saying yes, that doesn't override the fact that I am saying no. So if there are 3 owners of a business, 2 of them consent to the search, the third one says no, all 3 are present, that one no wins. Police are not allowed to do a consent search. Does that make sense? Now, people who can't consent are hotel employees or landlords. So if I'm a guest at someone's house, just on a very temporary basis, I had some friends of mine come to stay with us for 4 or 5 days a couple weeks ago. I could give permission to search the room they were staying in if they weren't here to say no. But a hotel employee or a landlord, someone staying there either at, in a hotel, no matter how temporary, but there's a business relationship there, or if I was renting an apartment, my landlord couldn't give permission for the police to search the apartment. So if it's a temporary thing, as a host-guest relationship, the host can give permission absent the consent of the guest. But if you're paying a hotel or you're paying rent and staying there in a semi-permanent fashion, the landlord, the hotel employees, those can never give consent, whether you're there or not. Make sense? All right, let's move on. Frisks. So in 1968, there was this very famous Supreme Court case called Terry v. Ohio. And essentially what the Supreme Court's decision in this case was that it is reasonable for officers to be able to pat someone down on the outside of the clothing to feel for weapons. So the reason they're allowed to do that is for officer safety, because officers don't want to talk to somebody who may be armed and trying to wait for the best opportunity to pull a gun and kill the officer. So for reasons of officer safety, if officers have reasonable suspicion, which is above just a hunch, but below probable cause, so if there's any real articulable reason for them to have suspicion that this person might be dangerous, might be carrying a gun, might be somebody that they shouldn't turn their back on, if they had that reasonable suspicion, they're allowed to do an outside the clothing pat down. They're allowed to go inside the clothing if it's like a large, bulky jacket. But other than that, it has to be outside the clothing. And anything they find, if they can, through that plain touch, because remember, it's not just plain view. There's plain touch, plain smell, all those things. If through plain touch, they find anything that is immediately identifiable as contraband, that is not an unreasonable search, and the Fourth Amendment doesn't apply. So if police officers are patting me down and that is obviously a gun, they're allowed to arrest me for it, take that gun. That wasn't an unreasonable search, even though they didn't have, not only did they not have a warrant, they didn't even have probable cause to search me. All they needed was reasonable suspicion and that plain touch. If something is obviously contraband, not necessarily a weapon. So the reason for the search is officer safety. But if it's plain touch and they feel something that's obviously contraband, even if it's not a weapon, it still doesn't count as a search. They're still okay. That's not a violation of the Fourth Amendment. So if they feel what is obviously a baggie of powder or a baggie of marijuana, that's not a violation of the Fourth Amendment. So as an addendum to this, in 2004, there was a case called Hibble v. 6th District. And Hibble is not misspelled there. There is supposed to be two I's. And in that case, so let me back up. There are some states that have a law that says you must identify yourself when police ask you to identify yourself. Not all states have it, but there are some states that have a law that says essentially that. Police can require you to identify yourself. And as part of these Terry stops in those states, police officers were not only doing the frisk, but they were also requiring people to identify themselves with no more than reasonable suspicion. And in Hibble v. 6th District, the Supreme Court had to rule whether that was constitutional or unconstitutional. And what they ruled was, it was constitutional. In other words, if a state has the law that says you have to identify yourself during one of these Terry stops, that does not violate your rights. So, check up on the state where you live, see if your state has that law. If it does, they are perfectly allowed to enforce that without violating your Fourth Amendment rights or Fifth Amendment rights or any other amendment rights. If your state does not have that law, the fact that it's constitutional to have it doesn't affect you. It doesn't mean the police get to require you to identify yourself absent that state law. Okay? All right. When somebody gets arrested, in other words, police have probable cause to believe that you've committed a crime and thus they are arresting you. They can do a warrantless search of anything in your immediate control. Now that, again, is going to get into some gray areas. What exactly constitutes your immediate control, right? But the underlying philosophy, the underlying justification here is that A, we don't want contraband to enter the jail. B, we don't want arrested people to have a hidden handcuff key, a hidden knife, a hidden gun, something that they can use to hurt an officer. And 3, we want to prevent the destruction of evidence. So even handcuffed, people can still destroy evidence if officers don't find it quickly. So anything in their immediate control, so definitely anything within arm's reach. Sometimes they've said anything kind of within the room. There's a gray area of exactly what counts as under their immediate control. But definitely anything within arm's reach, i.e. if there's a backpack next to them, if they were caught on a bed, you can definitely search under the bed or under the mattress, things like that. But interestingly, you cannot, as part of a search incident to arrest, you can't open a locked container. So if somebody on them during their arrest, you find a locked lockbox. As part of the search incident to arrest, that doesn't give you the right to do a warrantless search of the insides of that locked container. Okay? It also doesn't give you the right to search the contents of their cell phone. And that wasn't always the case. It wasn't until 2014. It was a case called Riley v. California, where prior to 2014, as part of a search incident to arrest, police could search the contents of your cell phone they found on you during an arrest. But after 2014, they're not allowed to anymore. They can confiscate your cell phone, they can take it, they can apply for a warrant to search it, but they can't just search it as under the justification of the search incident to arrest. But once again, we have to bring in plain view. So in other words, if they've confiscated your cell phone and while they're looking at it, you get a text message and that text message just pops up on the screen, well, that's plain view. They didn't search your cell phone. It was just the message was there. They didn't bring that message up. It was just plain view. Okay? So that part of searching a cell phone is allowed when it's plain view. When it comes to cars, there was a case called New York v. Belton that says if police have probable, if police arrest the driver of a car, that usually gives them the right to search the passenger compartment of the car. Okay? So we've pulled over a driver, we've arrested him. Now we're going to search the passenger compartment for evidence of the crime we arrested him for, or some other reason as part of that search incident to arrest. Okay? But then there was a case in 2009, Arizona v. Gant, that limited that right. So most of the time, under New York v. Belton, we can still, if you're arrested while driving a car, as part of the search incident to arrest, police are allowed to search the rest of the passenger compartment. But in Arizona v. Gant, they arrested the person after he had already, so he got pulled over, he left the passenger compartment of the car, then he was arrested for driving without a license, I think it was. And they took him, and then under the New York v. Belton rule, they searched the passenger compartment. But the Supreme Court ruled, what evidence are you going to find of driving without a license in the passenger compartment of the car? What reasons of officer safety is there for searching the passenger compartment of the car after you've already got the person out and arrested in the back of the patrol car? What destruction of evidence can come? So there is no immediate need. All of the kind of the justifications for the search incident to arrest don't apply there. You have the time to get a warrant. You have the ability to get a warrant. You don't have to worry about safety. You don't have to worry about destruction of evidence. So the reasoning for the search incident to arrest doesn't apply. So you can still sometimes search the passenger compartment when you arrest the driver, but not always. Another big one, exigent circumstances. And exigent circumstances is just a fancy way of saying it's an emergency. We don't have time to go get a warrant. There's some reason to believe that somebody is in imminent danger, or there's some kind of medical emergency, or it's very obvious that destruction of evidence is happening right now. In those cases, it's an emergency. We don't have time to get a warrant. We're just going to go in. So a lot of times on like movies and TV, there'll be this kind of joke trope thing where the officers are outside a door and they knock and nobody answers, but then it's like, oh, I hear a baby crying, don't you? Yeah, I hear a woman screaming for help. What they're trying to do there is kind of fake an exigent circumstance. And if you fake it, obviously, they'll probably get thrown out in court. But if it's a real emergency, if a woman really is on the inside of that apartment crying for help, oh, he's going to kill me, he's going to kill me. Police don't have to wait for a warrant. They can burst the door down and just go in. If a reasonable person would believe that an actual imminent danger or medical emergency, or somebody was, sitting there flushing evidence down the toilet, they're allowed to go in without waiting for a warrant. Vehicle searches mostly are covered by Carroll v. U.S., which is a very old court case all the way back from the 20s when police were searching Model Ts. In essence, for a vehicle search, all you need is probable cause. Once you have probable cause to believe that a crime has been committed or is being committed, and there's evidence in the car, once you've reached that level, you don't need a warrant. Don't even bother to call a judge. Don't need a warrant. Go for it. Now, there was a court case that I didn't write down the name of the actual court case, but there was a thing about pretext stops. Okay, so in other words, I suspect the driver of that car is smuggling drugs. I have no actual evidence of that. I don't have probable cause for that. I don't have reasonable suspicion for that. But I have a hunch that guy's smuggling drugs. So I'm going to find some pretext to pull him over. Oh, he rolled through a stop sign. He's speeding, whatever. Then I pull him over and start fishing for more evidence that he's actually smuggling drugs. The pretext stop is perfectly okay, as long as the police officers aren't lying about it. They can't make something up to pull them over for. But as long as that reason they pulled them over is actually a legally valid reason to pull them over, the fact that they only did it in order to try and find evidence of some other larger crime is perfectly okay. That's not unconstitutional. 1999, Wyoming v. Houghton, I don't know. something, Wyoming v. H. If you have probable cause to believe to search the driver, you can also search the passengers, because the thinking there is it's very, very easy for a driver to take contraband and go to his passenger and say, here, hide this. That's an incredibly easy thing to do. So if you have enough probable cause to search the driver, because it was so easy for the driver to pass off whatever evidence it is you're looking for to a passenger, you're also allowed to search the passengers. Chambers v. Maroney, 1970. If this court case was about the inventory of an automobile after it was impounded. So there's lots of different reasons why a vehicle might get impounded in the police parking lot. When that happens, police are allowed to do a routine vehicle inventory, i.e. a search of the vehicle in order to document exactly what's in it, what condition it's in, if there's anything that might be, unsafe. We don't want to impound a truck with a bomb in the back, something like that, right? So for a few different reasons, a normal procedure of inventorying vehicles that come into the impound lot does not count as a search. And at that point, anything you find inside is plain view. You are legally inventorying that vehicle when you found the contraband, and thus it is perfectly admissible into court as evidence against the vehicle driver, owner, whatever the case may be. Now, kind of similar to searches of a vehicle, kind of a related issue are checkpoints. You're driving along, all of a sudden police are stopping either every car or every fifth car or something. Those have gone all the way up to the Supreme Court. And in 1990, this case, Michigan v. Sitz, the Supreme Court ruled that checkpoints designed to protect the road from drunk drivers are perfectly constitutional. That is not a violation of your Fourth Amendment rights. Police are allowed to do a systematic check of drivers to see if they're drunk or under the influence. But again, they have to do it systematically. They can't pick and choose who to test for DUI. They have to test either every car or every third car or every fifth car, whatever. As long as there's some systematic way where they're checking some and letting others go, other than just, I think he looks funny. But then they started doing checkpoints for other things besides DUI. And in 2000, Indianapolis v. Edmond, the Supreme Court ruled that those other crimes, those aren't good enough of a justification to set up these checkpoints. So you can't force people to pull over so you can check them for, I don't know, a gun in the car, right? The only way you can do those checkpoints is for DUIs. Make sense? All right. At the border, you have basically no Fourth Amendment rights. Citizens, non-citizens, doesn't matter. If you're coming into this country, whether you're coming home or coming in as a visitor or moving here or whatever, citizen or non-citizen, you basically have no Fourth Amendment rights. The federal government or any other kind of government agent, in most cases, it's Customs and Border Protection. They can search your bags with absolutely they don't need a reasonable suspicion, they don't need probable cause, they need nothing. They can search whatever they want as deeply as they want. And these border searches also apply to ports and airports. So I've flown internationally a lot. Every time I fly home, I have to go through customs. And the customs agent opens my bag, searches through it, asks me, where are you coming from? Are you bringing anything back that, is illegal? No drugs, no, whatever. And the Fourth Amendment never enters into it. The Supreme Court has ruled that these, essentially your Fourth Amendment rights are completely overruled by the state's need to protect its borders from smuggling of all kinds. So when it comes to the international borders, you don't get to say no to a search. The other thing we got to talk about, kind of one of the last things for this subsection, are open fields, abandoned property, and public places. You have no reasonable expectation of privacy in any of these. So if I abandon my backpack in the middle of my college campus, and I'm not there, I've left it, it's just sitting on a bench somewhere, police don't need a warrant to open that. As long as it's obviously and clearly abandoned, police can search that container, whether it's a backpack or a plastic container or a metal trash can, doesn't matter. Because there is no reasonable expectation of privacy in anything that you've left in public and just abandoned. Similarly, open fields. So the police have no warrant requirement. It is not a search if they search just your open land. They can fly over your house in a helicopter, or they can fly over your property in a plane. They can use satellite images, any of those things. They can walk through a farmer's field. There is no Fourth Amendment protection from those open fields, right up until it reaches the curtilage of your home, which is one of those really fun words, curtilage. The curtilage of your home is where your reasonable expectation of privacy starts. And essentially the court said that curtilage around the exterior of your home is kind of where the intimate parts of your home life start. So your front porch, your garage, your attached garage, that kind of within that very small physical area on the very outside of your home. So if I had a bag leaning up against the front of my house on my front porch, that doesn't count as something in the open fields. That's in the curtilage of my home. Fourth Amendment still applies. And then finally, trash cans. Again, as long as they're not in the curtilage of your home, they are free game, no warrant needed. That goes for civilians, it goes for police, it goes for whoever. As soon as I take my trash can and I take it up to the curb so that the trash man can pick it up, I no longer have any reasonable expectation of privacy in it. Thus, police don't need a warrant. My neighbors can legally go through it. It becomes essentially public property as soon as I wheel that trash can to the curb. As long as they're not trespassing on my property, invading the curtilage of my home, perfectly legal, no Fourth Amendment requirement at all. All right, one more short subsection, and then we're done. I'll see you in a minute.